The police broke down her door without a warrant. What they found would free thousands of guilty criminals. This is the most controversial protection in American law. On May 23, 1957, Cleveland police received a tip that a bombing suspect was hiding in Dollree Mapp's home. 3 officers arrived at her door and demanded entry. Mapp called her lawyer, who told her something that would change American history. Do not let them in without a warrant. She refused. The police left, but they did not give up. Hours later, they returned with reinforcements. When Mapp demanded to see their warrant, an officer waved a piece of paper in her face. She grabbed it and stuffed it down her dress. What happened next triggered a legal earthquake. Officers wrestled her to the ground, handcuffed her, and searched every inch of her home. They never found the bombing suspect. But in her basement, inside a locked trunk, they discovered something else entirely. The trunk contained obscene materials. Illegal pornography that Mapp claimed belonged to a former boarder. It did not matter. Ohio prosecutors charged her with possession of obscene literature. A felony. Now here is where this gets strange. The Fourth Amendment had protected Americans from unreasonable searches since 1791. But there was a massive loophole. Even when police blatantly violated your constitutional rights, they could still use whatever they found against you in most state courts. The Supreme Court had created something called the Exclusionary Rule back in 1914. If police found evidence illegally, federal courts had to throw it out. But this rule only applied to federal cases. Each state could make its own choice. Ohio chose to allow illegally obtained evidence. So Dollree Mapp faced prison based on evidence found during a search that everyone agreed was unconstitutional. Let me put this in perspective. Imagine police break into your home right now without any warrant. They find nothing illegal. But in your garage, they discover an old parking ticket you forgot to pay. Under the rules in 1957 Ohio, you could be prosecuted. The violation of your rights did not matter. Evidence was evidence. Mapp was convicted and sentenced to 1 to 7 years in prison. Her lawyers appealed, focusing on First Amendment free speech arguments about the obscenity laws. They barely mentioned the illegal search. But when the case reached the Supreme Court in 1961, something unexpected happened. The justices saw a much bigger issue. They did not care about pornography laws. They cared about the Constitution being violated with zero consequences. Justice Tom Clark wrote the majority opinion and asked a devastating question. Clark asked this: if the exclusionary rule was necessary to protect the Fourth Amendment in federal courts, how could states ignore it without making the Constitution meaningless? The answer exposed an uncomfortable truth. For decades, state police had operated under different rules than federal agents. Local cops knew that even if they violated every constitutional protection, the evidence would still be admissible. There was no deterrent. No consequence. The wolf becomes the guardian of the chicken coop, wrote one dissenting justice years earlier. And the data proved it. States without the exclusionary rule had significantly higher rates of warrantless searches. Police departments developed cultures of cutting corners. Why bother getting a warrant when illegal evidence worked just as well? On June 19, 1961, the Supreme Court made its decision. 6-3. The exclusionary rule would now apply to every state in the nation. But here is what nobody tells you about this decision. It created a legal paradox that divides America to this day. Think about it. The exclusionary rule does not help innocent people. If police illegally search your home and find nothing, you were never charged anyway. The rule only helps guilty people. Criminals who actually possessed illegal items. The evidence proves they committed crimes, but courts must pretend it does not exist. Justice Benjamin Cardozo once said the criminal goes free because the constable has blundered. Critics called it the most controversial protection in American law. But supporters argued something profound. The Constitution is not just about catching criminals. It is about limiting government power. If police face no consequences for violations, constitutional rights become meaningless words on paper. This was never about Dollree Mapp. It was about every American who would come after her. What happened after Mapp changed American policing forever. Within 5 years, police departments across the nation rewrote their training manuals. Officers who never needed warrants suddenly had to learn Fourth Amendment requirements. Some departments resisted. In Los Angeles, the 1965 Watts riots were partially fueled by continued illegal search practices. Courts began developing exceptions. The good faith exception. Inevitable discovery. Exigent circumstances. Each one carved away at the rule while trying to preserve its purpose. And then came the critics. In 1971, Chief Justice Warren Burger called the exclusionary rule a monstrous price to pay for the rights of criminals. Studies attempted to measure how many guilty people went free. Some estimated 3 to 5% of felony cases were dismissed due to suppressed evidence. Others argued the number was far lower. But here is the question the Supreme Court could never answer definitively. Does the exclusionary rule actually deter police misconduct? After 6 decades, the evidence is mixed. Body cameras and civil lawsuits may do more to change police behavior than suppressed evidence. But here is what the critics miss. The exclusionary rule was never just about deterrence. It was about integrity. Justice Clark wrote that the judicial process must not become an accomplice to unconstitutional conduct. If courts use illegally obtained evidence, they become partners in the violation. The government cannot benefit from breaking its own laws. Today, the exclusionary rule remains the law of the land. Modified by exceptions, weakened by conservative courts, but still standing. Every time police want to search your home, they think about Dollree Mapp. Every time a judge excludes evidence, Mapp versus Ohio is cited. One woman who refused to let police into her house without a warrant changed how 330 million Americans interact with law enforcement. Dollree Mapp was released from prison in 1963 after serving 1 year of her sentence. She moved to New York and lived quietly until 2014 when she died at age 91. She rarely discussed the case that bore her name. But in one interview, she said something remarkable. She never expected to change anything. She just did not think police should break into people's homes. That simple belief, held by a woman in Cleveland with no legal training, forced the highest court in America to choose. Would the Constitution protect everyone equally? Or would state governments decide which rights matter? The Supreme Court chose protection. And whether you agree with the exclusionary rule or despise it, one fact remains. Every time you hear the phrase illegally obtained evidence, you are hearing Dollree Mapp's legacy. Now you understand how one illegal search created the most controversial protection in American law.